In July 2024, a group of YouTube creators filed a lawsuit in a California federal court. Their target, Apple Incorporated. The allegation is straightforward but significant. According to the complaint, Apple accessed and downloaded millions of YouTube videos without the creators' permission. The purpose, the lawsuit claims, was to train Apple's artificial intelligence models. The case represents one of the first major legal challenges by individual content creators against a tech giant over AI training data. At stake is the question of whether using publicly accessible video content for machine learning constitutes copyright infringement. The lawsuit was brought by content creators who make their living producing videos for YouTube. While the specific names and channels involved in the complaint have not been widely publicized in early reporting, the suit represents creators whose work spans educational content, entertainment, tutorials, and commentary. These individuals invest time, money, and creative effort into their videos. They monetize through ad revenue, sponsorships, and viewer support. According to their legal team, the creators did not consent to having their videos harvested for AI training. They argue that Apple's alleged actions undermine the economic and creative rights that copyright law is designed to protect. Central to the lawsuit is a dataset known as YouTube subtitles. According to multiple reports and academic papers, this dataset contains transcripts from approximately 3.8 million YouTube videos. It was compiled by researchers and has been widely used in the AI research community for training language models. The creators allege that Apple used this dataset, or datasets derived from it, to train its AI systems. The complaint emphasizes that the dataset was assembled by scraping YouTube without direct authorization from the video creators. The scale is enormous, millions of hours of content, representing countless individual works. The lawsuit describes a process in which automated tools accessed YouTube's platform to collect video transcripts and potentially video files themselves. YouTube hosts an immense library of user-generated content, much of it publicly accessible. The creators allege that Apple, or entities working on its behalf, used bots or scraping software to systematically download content at scale. This process bypasses any direct negotiation or licensing agreement with the creators. According to the complaint, the scraping was indiscriminate. Videos were taken regardless of whether creators had enabled downloads or explicitly restricted use of their content for commercial purposes beyond YouTube's own platform. The creators' legal complaint centers on alleged violations of the Digital Millennium Copyright Act, or DMCA. Enacted in 1998, the DMCA protects digital content and outlines penalties for unauthorized copying and distribution. The lawsuit argues that Apple's alleged scraping and use of YouTube videos constitutes copyright infringement under the DMCA. Each video is an original work owned by its creator. Downloading and processing millions of these works without permission, the creators claim, violates federal copyright law. The DMCA provides for statutory damages that can range from hundreds to tens of thousands of dollars per work infringed, potentially resulting in massive liability. Apple has not remained silent. According to court filings and statements to the press, the company denies the allegations. Apple's legal team argues that the use of publicly available data for AI training falls under fair use, a doctrine in copyright law that permits limited use of copyrighted material without permission for purposes such as research, commentary, and education. Apple contends that training AI models is transformative. The videos are not reproduced or distributed to users, but rather analyzed to teach algorithms about language, context, and patterns. The company also argues that it did not directly scrape YouTube, but rather used datasets compiled by third-party researchers for academic purposes. Fair use is a critical but often ambiguous area of copyright law. It allows copyrighted material to be used without permission in certain circumstances. Courts evaluate four factors: the purpose and character of the use, the nature of the copyrighted work, the amount used, and the effect on the market for the original. Apple's argument hinges on the first factor, that AI training is transformative and does not substitute for the original videos. The creators counter that their work is being commercially exploited without compensation, harming their market. Legal experts note that fair use cases involving AI are still rare, and courts have not yet established clear precedents. This lawsuit could help define the boundaries. YouTube, owned by Google, occupies a complicated position in this dispute. The platform's terms of service grant creators ownership of their content, but also give YouTube a broad license to display, distribute, and promote videos. However, YouTube's terms do not explicitly authorize third parties to scrape and download content for AI training. The lawsuit notes that YouTube has mechanisms to prevent bulk downloading, including rate limits and technical protections. The creators argue that Apple's alleged scraping violated not only their rights but also YouTube's terms of service. YouTube has not been named as a defendant in the case, but its policies and enforcement will likely be scrutinized. YouTube's terms of service explicitly prohibit unauthorized access, scraping, and automated data collection without prior written permission. The platform employs technical measures, including CAPTCHA challenges and IP blocking, to deter bots. However, the lawsuit suggests these measures were either bypassed or insufficient to prevent large-scale scraping. The creators point out that YouTube's own Content ID system protects copyright holders from unauthorized uploads within the platform, but does not address external scraping for AI training. The case raises questions about whether platforms like YouTube have a duty to prevent third-party scraping, and whether creators can rely on platform protections alone. Apple's AI initiatives are marketed under the brand Apple Intelligence. The company has integrated machine learning across its products: Siri, photo recognition, predictive text, and more. Apple emphasizes privacy and on-device processing, distinguishing itself from competitors who rely heavily on cloud-based models. However, training these models requires vast amounts of data. The lawsuit alleges that Apple turned to scraped YouTube videos to build robust language and vision models. Apple has not publicly detailed all of its training data sources, citing proprietary concerns. The creators argue that Apple's silence on this issue is itself telling, suggesting the company knows its data collection practices may not withstand legal scrutiny. This lawsuit is part of a larger, global conversation about AI and copyright. Tech companies argue that training AI on publicly available data is necessary for innovation and falls within legal bounds. Artists, writers, musicians, and now video creators counter that their work is being used without consent or compensation, enriching corporations while devaluing human creativity. Similar lawsuits have been filed against OpenAI, Stability AI, and others. Courts and legislatures are grappling with how to apply 20th-century copyright laws to 21st-century technology. The outcome of the Apple case could influence not only how AI companies source training data, but also how creators protect and monetize their work. Few court decisions directly address AI training and copyright. In 2015, a case involving Google Books found that digitizing books for search was fair use because it was transformative. However, that case did not involve creating derivative AI models. In 2023, artists sued AI image generators, arguing their work was scraped without permission. Those cases are ongoing. The Apple lawsuit will test whether video content, which involves more creative and economic investment than text or static images, receives stronger protection. Legal scholars note that judges may be influenced by the commercial nature of Apple's AI products and the scale of the alleged infringement. If the court finds in favor of the creators, the potential damages could be staggering. The DMCA allows for statutory damages of up to $150,000 per work willfully infringed. With millions of videos allegedly scraped, the liability could theoretically reach billions of dollars. More realistically, the court could award actual damages based on lost licensing revenue, or issue an injunction preventing Apple from using the disputed data. The creators may also seek a court order requiring Apple to delete models trained on their content. Apple, for its part, could negotiate a settlement, establish a licensing framework, or win outright dismissal based on fair use. The lawsuit has drawn attention from across the tech and creative industries. Some content creators have voiced support, viewing it as a necessary stand against corporate overreach. Others worry that overly strict rules could stifle AI research and innovation. Tech companies are watching closely, if Apple loses, they may face similar suits. Some industry groups have called for clearer legislation to define permissible uses of public data for AI. Meanwhile, advocacy organizations for artists and creators are urging Congress to update copyright law to explicitly address machine learning. The case has become a flashpoint in the debate over who benefits from the AI revolution. The case is currently in the discovery phase, where both sides exchange evidence and documents. The creator's legal team has requested internal Apple communications, training logs, and dataset inventories. Apple is expected to file motions to dismiss or narrow the claims, arguing fair use and lack of direct infringement. If the case survives dismissal, it could proceed to trial, a process that may take years. Alternatively, the parties could reach a confidential settlement. Legal observers anticipate that the case will eventually reach an appeals court, given the high stakes and novel legal questions. The outcome will depend on how judges interpret fair use in the context of commercial AI development. For YouTube creators and other digital artists, the lawsuit represents a test of their ability to control how their work is used in the age of AI. A victory would establish that content creators have rights beyond the platforms they publish on, and that tech companies cannot freely harvest their work. It could lead to licensing agreements, royalty systems, or opt-out mechanisms for AI training. A loss, however, could signal that publicly shared content is fair game for any commercial use deemed transformative. Creators are watching closely, knowing the decision will shape their livelihoods and creative autonomy for years to come. For Apple and other AI developers, the lawsuit poses a fundamental challenge to current data practices. If courts rule that scraping copyrighted content without permission is infringement, companies will need to fundamentally rethink how they build training datasets. Options include licensing content directly from creators, using only public domain or explicitly licensed material, or lobbying for new legislation that provides a safe harbor for AI research. Some companies have already begun signing deals with publishers and stock media providers. A ruling against Apple could accelerate this shift, raising the cost and complexity of AI development but potentially creating new revenue streams for creators. As of now, the case remains unresolved. No trial date has been set, and both sides continue to litigate procedural issues. The court has not yet ruled on Apple's motion to dismiss. Legal experts caution that the case could take years to reach a final verdict, and any decision will likely be appealed. The questions at the heart of the lawsuit, whether AI training is fair use, whether platforms have a duty to prevent scraping, and how to balance innovation with creator rights, are complex and without easy answers. What is clear is that this case will be closely watched, and its outcome will reverberate far beyond the courtroom, shaping the future of AI, copyright, and digital creativity.